Right, we will start. I presume you all remember what we discussed last week with regard to the legality of the bills of exchange ordinance. Then, what is a bill of exchange? Definition of a bill of exchange, which is quite important. Then we spoke of the section 3, and then the definition, the interpretation section of the bills of exchange ordinance. I will let me get this. Okay, until it downloads, we will go through this. 1 second. Right. Then we also spoke of under what law the bills of exchange ordinance and the bills of exchange is governed. As you all know, this is a quick catch up. Is based on the English law. Then what are the other required legal nature? What is a bill of exchange? We spoke of how it originated. Then we spoke briefly about the English Bills of Exchange Act in 1882, introduced by Mackenzie Chalmers, and then we also spoke of the Sri Lankan Bills of Exchange Ordinance number 25 of 1927. Then we went in detail with regard to the definition of a bill of exchange, whether it's an unconditional order in writing drawn by one person addressed to another person, so on and so forth. Right? I hope you all remember something small matter that with regard to these bills of exchange. Essentially, keep in mind that you need to peruse this. You need to read through this bills of exchange, ordinance and the laws, and whatever the material that I share with you quite often. Otherwise, you are definitely going to forget about this, because it's not every day that you use the laws which is applicable to bills of exchange. Then we spoke of what you mean by in writing, signed by the person giving it, what constitutes signing. Then the matter of requiring the payee to the drawee to pay on demand. What do you mean by at a fixed or determinable future time? The fact that it should be determinable. It cannot be what you call based on a condition or based on a happening of an event which may be or may not happen. Then some certain in money, right? So on and so forth. Then capacity of the parties. What do you mean by consideration? And by now we know consideration is an English concept. Valuable consideration is an English concept. Then the law of contracts in Sri Lanka are governed under the English law. Therefore, the bills of exchange ordinance, yes, you take it as a whole, and that framework is governed under the English law. Then again, we spoke of capacity of the parties. Keep in mind, this is the only area when you discuss about capacity of the parties, you might remember when you all did the law of contracts. What do you mean by capacity? Capacity to enter into a contract, right? There, the law with regard to capacity to enter into a contract is governed under Roman Dutch law. You'll remember, and this is the only place where the Roman Dutch law or RDL supersedes the English law. Keep that in mind. It is quite important. Then we spoke of the different types of parties who get involved in a bill of exchange, and then we spoke accommodation party, and then we left it there. So we'll take it from there uh, on bills of exchange. Let's see whether this is on downloaded. Uh, okay, it has interpretation. I hope you all can see my screen. Then we speak of what do you mean by endorsement of a bill of exchange. Now look at these words, right? We are talking about endorsement, but in the bills of exchange, you don't find the term endorsement. Instead, what you find is endorsement, right? Look at this endorsement. What do you mean by endorsement? Right. Endorsement means an endorsement completed by delivery. The term endorser comes from the word endorsement, and endorsement is more or less, the English dictionaries prefer that we refer to the word endorsement and not endorsement, but more or less both are the same, right? Both are the same. To endorse or endorse means to write one signature or to sign on the back of a document and thus give you approval or sanction, you call it, on that document. So endorsement is the act of endorsing, and so endorsement is the act of endorsing, and the endorser or endorser is the person who performs that act of endorsement, right? So bills of exchange and checks can be negotiated by the payee. You know who the payee is? The person who is getting the money, whose name, on whose behalf, in whose favor it is written. So the payee endorsing the check or the bill of exchange by writing his name on the back and transferring it, right? So as per section 2, you can see endorsement or endorsement means an endorsement completed by delivery. So merely signing at the back of the bill of exchange, it will not constitute a legal or a valid endorsement. Keep that in mind. So in addition to signing it, that bill must be delivered, or there should be a delivery of the bill after endorsing that. So now we will see how all this endorsement occurs, right? Now, what happens is when a payee of a bill is drawn to order of that payee, he may wish to transfer that, right, to another person. So that is done by endorsement. There can keep this in mind very carefully. There can be no endorser of a bearer bill. Because why? Because all bearer bills are transferred by simple delivery. So you don't need to transfer it. You don't need to endorse it to transfer. You can transfer it by a mere delivery. So keep in mind, no endorsement is there for bearer bill. Bearer bills are the bills that you and I know. Pay X or the bearer. Pay X or රැගෙන right? Now, what are the liabilities of an endorser? Liabilities of an endorser is provided under section 55 of the Bill of Exchange Ordinance, right? Section 55, subsection 2. The endorser of a bill, by endorsing it, what happens? The endorser engages that on a due presentment, the bill, it shall be accepted and paid according to its tenor, and that if it is be dishonored, he will compensate the holder or a subsequent endorser who is compelled to pay it, provided that the requisite proceedings on dishonor are duly taken. What you have to keep in mind is, so the drawer draws the bill in favor of the payee who becomes an endorser and endorse it in favor of someone else who becomes the endorsee. Or again, for understanding purposes, he is also a payee. Now, this is the payee of the third level. That payee also may endorse it. So that's why this whole concept of bills of exchange is quite popular. And once an endorser endorses it and give it to the endorsee, which is the receiver of that endorsement, right, of that bill of exchange, he is liable on the bill. He is liable that to the effect that on the due presentment of the bill that it shall be accepted and paid. So that because of that guarantee on these laws of merchant and this whole bills of exchange ordinance is popular, right? So an endorser is precluded, you can read this, from denying to the holder in due course the genuineness and regularity in all respects of drawer's signature and all previous endorsements. So you as the endorser of a bill, right, you are liable to everyone in the chain of title subsequent to your endorsement. You are liable to your endorsee, and once that endorsee endorses and give it to another endorsee, you're liable. So that whoever the holder in due course, whoever is holding the bill in due course, in bills of exchange ordinance language, you call yatakali dharakya. Holder means dharakya. Holder in due course, or in short form, you call HDC. HDC, right? Holder in due course, right? You are liable to the holder in due course. However, if your signature is forged, you are not liable on the bill, because then the whole concept differs. In the case of Don Cornelis versus D'Souza and Company Limited, this was in 1965. I am giving these references to you. 68 new law reports. In page 161, it was decided that you are not liable on forged endorsements. Now, who are the different types of holders of bills of exchange? Right? A holder of a bill of exchange is a person who is physically holding the bill, under whose possession the bill is. Right? It may be a payee or an endorsee, either of two, the possession of the bearer. So, if you see section 2, which provides for you see how they have defined who a holder. Holder means the payee or endorsee of a bill or note who is in possession of it, right? Or the bearer thereof. But any person in possession of bearer bill is a holder of the bill. However, to be a holder of an order bill, holder of an order bill, the person in possession must also either be the original payee. Remember this, right? The person to whom the bill has been endorsed. Now, listen to this. You understand that if it's a bearer bill, the holder, so it is transferred by mere delivery. You don't need to endorse it. But if it's a order bill, you have to endorse it and deliver it. Hold in this legal language doesn't only mean that you're holding, let's say for an example, this is the bill. You are not only holding this, you have the title to this, right? In the most, let's say, practical sense, let's say you give your clerk or your driver to deposit a bearer check. When you give it to him, the moment he takes it to his hand, if it's a bearer bill, you can argue technically that he has the title to that bill because it's a bearer bill. Of course, cheating and of course, don't think about those. But insofar as bills of exchange ordinance is concerned, when he holds the bill in his hand, he has the title to that. Let's say you give a similar bill to a check to your driver to go and deposit your account. But here, it's not a bearer bill, it's an order bill. Pay Rangaliyanage or order of. So if I give that check to my driver to go and deposit it, once he get it to his hand, he doesn't become the holder. Why? It is not under his name. For him to get the title, either I need to endorse and give it to him. I'm not going to endorse it in his favor. No, I'm just going to give it to him after endorsing it under my name. So if it's an order bill, for a person to get the title of it, it should be either the original payee, here in this check, me, or endorse it in favor of a endorsee. Then only the title passes. So that's the holder, normal holder in the context of bills of exchange ordinance. Now, I mentioned about holder in due course, yatha kali dharakya. A holder in due course is defined in section 29 of the bills of exchange ordinance, section 29. This is one of the most important areas and provisions of the bills of exchange ordinance. A holder in due course is a holder, right, who has taken a bill complete and regular on the face of it under the following conditions. Now, before going on to the conditions, look at the first sentence, right? Look at the first sentence. A holder in due course is a holder who has taken a bill. So there should be delivery. Complete. What do you mean by complete? We will see. And regular. What do you mean by regular? On the face of it. What do you mean by regular on the face of it? We're going to discuss all these things because these are all important when you are going to discuss as to who a HDC or holder in due course or yatha kali dharakya is. And then we are going to discuss what's so important about this holder in due course. All right. So the conditions that he became the holder of it before it was overdue and without notice that it had been previously dishonored, if such was the fact. So if first thing is he became the holder because before the bill of exchange became overdue, or he got it without the knowledge that this particular bill was previously dishonored, if it was the case, right? Secondly, that he took the bill in good faith and for value. Good faith and value, these are quite wide interpretations are being given and quite higher level of expectations are expected to prove or to disprove, right? And that at the time the bill was negotiated to him, he had no notice of any defect in the title of the person who negotiated it. I want you all to keep this also quite specifically in your mind. took the bill in good faith and for value, and that at the time the bill was negotiated to him, right? Bill was negotiated to him. He had no notice of any defect, no notice of any defect in the title of the person who negotiated it. So how come it's going to be proved or disproved? Let's see, right? Complete and regular. First thing you saw here, it should be has taken complete and regular. What do you mean by complete and regular? A bill is incomplete. Listen to this. A bill is said to be incomplete if the name of the payee or drawer is absent. A check that is mutilated, indicating its cancellation, is not regular. Right? I will give, this was decided in the case of Ingham versus Primrose. Long time ago, they have decided, they have fought and they have decided this. What we have to do is just to read what they have cracked their brain for. Ingham versus Primrose. I hope that you are jotting down these details for your information. Then, what's next? Right? Complete and regular. And here, before it was overdue. What the condition became the holder of it before it was overdue. What do you mean by that? An overdue bill ceases to be negotiable and may be transferred only subject to the defects affecting it at maturity before it was overdue. Section 36(2). How long a bill continues to be negotiable? Where an overdue bill is negotiated, it can only be negotiated subject to any defect of title affecting it and at its maturity. And thenceforward, no person who takes it can acquire or give a better title than that which the person from whom he took it had. Right? Understood? Right? Then, in good faith and for value, where were we? We were in 29. We were in 29. Right. In good faith and for value. What do you mean by in good faith and for value? A thing is deemed to be done in good faith within the meaning of the Bills of Exchange Ordinance, where it is in fact done honestly, whether it is done negligently or not. There are many things that they have specified this or explained this. I hope you all are jotting down your notes. I'm drawing your attention to section 92, the Bills of Exchange Ordinance. Right? But this is what. So, what do you mean by good faith? There should be honesty. Honesty is different from negligence. So, you can do an honest act but negligently. Right? Cheating, if there is cheating, you are not honest. If there is a question on is as to your integrity, you are not honest, although you are not negligent. So negligent is different. This test to pass good faith doesn't check whether you are negligent or not. It checks whether you had good faith or not, or whether you've been honest or not. And that is where you need to check, right? Then consideration for a bill of exchange. Look at this. Consideration for a bill of exchange need not be adequate. So that's a basic norm of the law of contracts. Under law of contracts, you all discussed that consideration, or if you all have not, keep this in mind. Consideration is a part of an ingredient which requires for a legally binding contract, or in particular you call it valuable consideration. Consideration need not be sufficient, it should be adequate, right? So for an example, let's say I will explain it with an example, right? So this pen, right, or this highlighter, whatever you call it, let's say it's 50 rupees retail price. I give him 40 rupees, right? He can't say I cheated. There was a consideration passed. For me, no, it's not. It's 130 apparently. I give him 100, or I give him 120 or 110, but not the actual consideration which he asked for. But that doesn't invalidate a contract. Consideration need not be sufficient, it should be adequate. So, insofar if the court decides 110 is adequate, the contract is valid. Here, going a step further than that, you have to keep this in mind. So, consideration for a bill of exchange need not be adequate. However, inadequacy of consideration may be, right? It's not shall be. It may be an evidence of bad faith. For an example, some people say it's 130. You have all the money with you, but just to make sure that you don't pay the full 130, you have 200 rupee notes, and then you have 20 rupee notes, and then you have coins. But then again, what do? You tell him, look, I have only 100 rupee note and 5,000 rupee note. I don't have any change, and you give him the 100 and he accepts it, right? That's bad faith. But whoever who is imputing that should prove that. So that is where we stand. Good faith and for value. Good faith and for value. There should be good faith. So in the event consideration is not adequate, it doesn't by itself. Inadequacy of the consideration itself wouldn't invalidate that contract, bill of exchange. You receive a bill of exchange, let's say for 10,000 rupees for certain goods that you sold, right? So Drover is your buyer. He gives you a check for 10,000 rupees for goods received, value received, 10,000 worth of. But your goods or the value received maybe for some reason for him is not 10,000. Let's say it's 9,500. Consideration is adequate. You didn't know about it. Bill of exchange is valid, right? That is valid. But if you knew it and in bad faith you gave that 9,500 worth of goods for a check of 10,000, then bad faith is involved. Then that is an issue, right? Now we go to section 30. Right. There is a presumption. Now, with regard to this proving of good faith all the time by the parties is a, what do you call it? It's not that easy. So there is a presumption it's a rule of law that certain things are presumed, right? So here presumption of value and good faith is it goes like this. Every party whose signature appears on a bill is prima facie deemed to have become a party thereto for value. So if your signature is there on the bill, invariably the law thinks, unless you prove otherwise, right? Unless you prove it is not the case, if your signature is there on a bill, the law thinks that you are a party to the bill, right? Then every holder of a bill is prima facie deemed to be a holder in due course. So prima facie, every holder is deemed to be an HDC or යථාකාලී ධාරකයෙක් විදිහට සලකනවා. However, if it in an action on a bill, it is admitted or proved that the acceptance, issue or subsequent negotiation of the bill is affected with fraud, duress. Duress කියන්නේ අනිසිල් බලපෑම් කිරීම. Duress. Or force and fear or illegality, the burden of proof is shifted. Normally, the burden of proof is on the person who's accusing someone of something. So I accuse someone to have cheated. It is on me to prove that he cheated, right? So same thing goes on this. The law assumes or presumes good faith and value. However, if I prove that there was fraud, duress or force, the burden of proof on value and good faith shifts to the other person, right? It's important that you are aware of it. Unless and until the holder proves that subsequent to the alleged fraud or illegality, value has in good faith been given for the bill, right? So keep those in mind. Holder in due course is quite important to see the authenticity and the origin of and the title to the bill, right? Now, holder for value is another term. Now we are talking about holders of a bill. Holder we spoke of. Then holder in due course we spoke of. Now holder for value. Look at this. Listen to this carefully, right? Section 27(2). Value design. Where value has at any time, I will put it like this. If a holder for value need not himself have given value for the bill, where value has at any time, right? Where value has at any time been given for a bill, the holder is deemed to be a holder for value as regards the acceptor and all parties to the bill who become parties prior to such time. So let's say, for an example, I am the holder, right? But I am the holder of the bill, but I did not give value to the drawer on the bill, but somebody else did. Still, if the value was given on the bill, which I am holding it now, I am deemed to be a holder for value as regards the acceptor and all parties to the bill who became parties prior to me, right? Section 27(2). So holder for value also becomes a holder in due course, right? Now, rules related to the signature, right? Signature on a bill. Keep in mind that it is an important ingredient that the signature of the bill should be there. We have to examine the main general rules governing the signature and forged and unauthorized signatures. So what we will be covering under this is whether there should be a signature, what type, then the effect of forged and unauthorized signatures on bills of exchange. Right, we will see this in a later part when it comes to bills of exchange as to what forged and unauthorized signatures on checks and what their effects are. Now, section 93(1), where is this? Section 93(1), we just came near that earlier. right? When we spoke of good faith. Section 93(1) says like this, right? Whereby this ordinance, any instrument or writing is required to be signed by any person. It is not necessarily that he should sign it with his own hand, but it is sufficient if his signature is written thereon by some other person by or under his authority, right? So, in the case of a corporation, whereby the ordinance, it's sufficient if the instrument or writing be sealed with the corporate seal, right? So no person is liable as drawer, endorser, or acceptor of a bill who has not signed it as such, right? We spoke that in section 23. However, the signature may be written by someone else by or under his authority. So a person who signs a bill only as an agent or representative will not be personally liable if such fact is clearly shown on the bill. So you write in a bill of exchange, you pay someone either to the order or bear a bill. You sign, let's say, your signature, your personal signature, and you put your title in your company, the title you hold in your company, right? Let's say the accounts assistant, something. Then you are indicating that you are writing the check or the bill of exchange as an agent of your company. Until and unless you indicate that, you are liable personally on the bill. Of course, you are a party. There's no two words about that. But then again, your liability comes whether you are as the originator of the bill or as an agent of the bill, and depending on the facts of each case. In a particular case, the court held that the party to the bill had signed in a representative capacity and was therefore not personally liable. That's what I just covered. But there are certain other cases to show otherwise also. In certain other cases, the courts have, these are England judgments pronounced by English courts, where the courts have, in certain instances, have made the agent also personally liable. But that all depends on facts of the case. In determining this, whether your signature on a bill is that of the principal or that of the agent in whose hand it is written, depends, and it will be interpreted by courts favorable to the validity of the instrument. So based on the, what you call, what is most favorable to be applied, the law will decide accordingly whether who is liable, whether it's the company who is liable or who's the, whether the agent or the servant is liable. Forged or unauthorized signatures. We are still in signatures. Section 31, if I'm not mistaken. 31 subsection 2. Yeah. So now we spoke that a bill is payable to bearer is negotiated by delivery. This is negotiation. But if it's order, it should be endorsed and then delivery, right? Section 24 says, subject to the provisions of this ordinance, right? It says, in the case of a bill payable to order, a forged or unauthorized signature is wholly inoperative. Through such signature, no rights can be obtained. If it's different if it's a bearer bill, because you don't need a signature in a bearer bill, right? So keep that in mind. Now listen to this. Where the pay is a fictitious pay or non-existing person. Pay is a fictitious or non-existing person. A forged signature effectively passes title. Why? Since such a bill is regarded as payable to bearer. For an example, there is a case where pay Spider-Man or whoever, whatever, and just it left from there. It doesn't indicate whether it's a bearer bill or an order bill. If it's a fictitious pay or a non-existing person, it will be considered by law that it is a bearer bill. So even if it is a forged signature, that has no application in a bearer bill. For a bearer bill, you don't need a signature to negotiate, to transfer the title. It's done merely by delivery. Who is in possession of becomes the holder, right? So there, if it's a fictitious person, let's say pay cash and signed a bill, becomes the whether the signature is forged or not is not an excuse, right? Okay. If there are questions, I'm going on and on. If there are questions, please do ask me, right? Okay. Then we go to negotiation of the bill, right? Negotiation and transfer. We spoke of it even last week. We will further go through it because it's that important and see what are the other aspects of negotiation and the legal, what do you call, restrictions and results, limits, right, and effects of negotiation, right? Now by now you know the whole purpose of having a bill of exchange is the ability of that can be exchanged from person to person and settle whatever your debts, right, and that's why it has become a very, what you call, viable and a very useful facility. Is used by almost everyone in the business sectors. A bill is negotiated when it is transferred from one person to another. Bill is negotiated when it's transferred from one person to another in such a manner as to constitute the transferee the holder of the bill. For all this time we spoke of who is an holder of the bill. What do you mean by negotiability, right? So holder of the bill, you get the holder in due course, holder in value we spoke of. So if it's transferred from one person to another person in settlement of debts, right? Such a manner as to consider the transferee the holder of the bill, right? I'm reading section 31. I will. Right. While in the case of a bill payable to order, negotiation is by endorsement of the order completed with delivery. A bill payable to bearer is transferred by delivery alone. Section 31. Right. Requisites of a valid endorsement specified in section 32. So how do you endorse this? Right? The endorsement must be written on the bill and be signed by the endorser. It must be an endorsement of the entire bill. You can't endorse half of the bill. If it is a bill written for 50,000, you can't endorse it for 30,000. Then it becomes conditional and loses the character of a bill of exchange. It should be an unconditional order in writing. When the bill is payable to more than one person, all must endorse, unless the one endorsing has the authority to endorse on behalf of the others. There are, let's say, two payees. Both of them will have to endorse if they want to endorse. Endorsing by one person won't do it unless he has the authority to sign on behalf of the other person, right? Where the payee or endorse is wrongly designated or his name is misspelled, he may endorse it as the name wrongly appears and add his proper signature. Example, let's say in the bill, right? Now, well, for example, now this is how my name is spelled. But in the bill of exchange or the check that I received, my name is spelled like this, right? It happens quite frequently. So there's an A missing, right? There is an A missing in Lienage. If I to endorse that, I cannot write my correct name, Ranga Lienage, N-A-G-E, and endorse it. Right? I have to write the same name, what is appearing, what was stated there, and put my correct signature. This is a rule as required by the Bill of Exchange ordinance. If you write your correct name, that means that the drawer, the pay, you are not the pay. The pay is Ranga Liynage. You understand? So if you are representing that you are one and the same person, you have to write it as the name which is appearing as the pay and put your correct signature. Right? The payer may disregard any condition attached to the endorsement. That's up to the payer or the drawee of the check, which is stated in section 33. An endorsement in blank makes the bill payable to the bearer. For an example, you get a bill of exchange, pay, let's say Ranga Lienage or order. Ranga Lienage ho anaparidi gevanu. I turn the check aside and just sign it blankly. I made the order bill, I converted the order bill into a bearer bill now. I did put a name of the endorsee or the next pay of the check, right? Thereby, I made it a bearer bill. A bill with a blank endorsement may be converted by a subsequent holder to a specially endorsed bill that is endorsed specially to a person. So you endorse it or make it an order check. So you can make an order check to a bearer check or bearer check to an order check, depends on the manner of endorsement of the check, right? A restrictive endorsement prohibits the further transfer of the bill. Restrictive endorsement, section 35, right? For instance, if it says pay D only, where a restrictive endorsement permits further transfer, right? Pay D or order for collection. All subsequent endorsers takes the bill with the same rights and subject to the same liability as the first endorsee under the restrictive endorsement. Right? Understood? Okay. Now there are now we are still at bills of exchange. We haven't, so to speak, discussed about the law on checks. So the last part on bills of exchange are these words that you need to be aware of. First thing is, what do you mean by lost bills, right? Where a bill has been lost before, it is overdue. The holder may apply to the drawer to give him another bill of the same tenor. Section 69 of the Bills of Exchange Ordinance, right? And also 70 read through, right? Then you get another terminology called bills in a set, right? Where a bill is drawn in a set, each part of this set being numbered and containing references to other parts, the whole of parts constitute one bill. Right? And multiple in a set, whole interreferences, whole set constitute one bill. Where the holder of the set endorses different parts to different persons, he is liable as if they were separate bills. Normally it's considered as one bill, bills in a set. But normally you don't come across this because nowadays people don't use bills of exchange much, in the sense bills of exchange, so to speak, not checks. Checks are very frequently used. We will see what the differences are in a moment, right? The acceptance may be of only one or some parts. We're talking about bills in a sense. Then the most popular among the bankers is this promissory notes, or some call pro notes. Some important or salient provisions of promissory notes are as following. In the bills of exchange ordinance, the references with regard to promissory notes are provided under section 85 to 91, right? So section 85 defines promissory notes as this. Look at this. It's an unconditional promise in writing by one person to another, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or bearer. Right? So section 85 is that. Then delivery is necessary, it says, right? Delivery is necessary. It is completed by delivery. What can you gather from these two sections, 85 and 86, right? Where a note is payable on demand, it must be presented for payment within reasonable time. These are other requirements of pro notes. Where it is a payable at a particular place, it must be present for the payment there, so on and so forth, right? Now, strictly speaking, although it is mentioned and defined in the Bill of Exchange ordinance, a promissory note is not a bill of exchange, strictly speaking. Why? In a bill of exchange, there is a drawer, there is a drawee, and there is a payee. In promissory note, these three parties are not there. There's only two parties. The drawer is there, the payee is there. The party who is receiving the funds are there. So it's not a bill of exchange. And there is a different definition given for promissory note. If you look at that definition, the maker of the promissory note engages to pay it and is precluded from denying to a holder in due course the existence of the payee and his then capacity to endorse. Right? So keep those things in mind. And certain other requirements of a bill of exchange is not applicable to promissory notes, such as presentment for acceptance, acceptance supra protest. Don't worry about those things for this course. So what you basically have to keep in mind is certain characteristics and certain requirements that are applicable for bills of exchange are not applicable for promissory notes. Promissory notes are defined in section 85, of the Bills of Exchange Act, and the provisions which related to promissory notes are provided in section 85 to 91 of the Bills of Exchange Ordinance. And when you saw the definition which we just read out a while ago, strictly speaking, it is not a bill of exchange. It's different, right? Then now certain important rules governing actions based on bills of exchange. Action means legal actions. Right? What you need to keep in mind are as follows. An action on negotiable instrument is time barred. You can institute action on a negotiable instrument from up until 6 years from its date. Date of a bill of exchange is the date which is appearing on the bill of exchange, right? For an example, let's say Silva has given a check dated 1st of January 2020 for 1,000 rupees to Fernando, let's say, right? And check is dishonored by the bank. Fernando has up to 6 years, that is up to 1st of January 2026 to sue Silva on that check, right? It's a requirement under section 6 of the prescription ordinance. කාලාවරෝධ ආඥා පනත. කාලාවරෝධ. It prescribes certain limitations in terms of time where you can file action. Right? Then, although English law applies to bills of exchange, like checks and promissory notes, once a person sues on such instrument, right, the procedure applicable thereof is not English law, it's the Civil Procedure Code, right? Code of Sri Lanka. Third, under the provisions of the Sri Lankan Civil Procedure, there is a section under Chapter 53, if I'm not mistaken, under Civil Procedure, under Section 703 and 704 and 705, where you can use these checks and file summary actions. You will discuss, if not already, what are summary actions, what are regular actions. Summary actions on liquid claims, right? There, before he can take steps to define. So once you file action against a party on a check, let's say default, under 703 of the Civil Procedure Code, the other party, the defendant, can't enter into the case until he obtains, let's say, approval from the courts, right? Then, what else? Yeah, insofar as, so that is on bills of exchange or bills of exchange. Before I go to the checks part, anyone has any question? You can write. The lecture is still not over. Right? No? No questions? Right. Then the law on checks. Now, check is a bill of exchange or bill of exchange, right? And it's the most commonest negotiable instrument in the world. Most common, right? The advantages, the audience. Why would your customers use checks? Please, I want your responses. Otherwise, both you and I are going to sleep. what are the, or rather, why would the customers of the banks use checks? Answer to this question, please. Why? I'm waiting for your answers. I see new people also have joined. Yes. Why would the customers of the bank use checks? What are the advantages of using checks? Simple answers. I don't want lengthy answers. First one. Uh, First one, you have to carry cash, right? Oh, why is it? Yeah, is it there? Yeah, you don't have to carry cash. It's very convenient. Ashika, yes, very good. Yeah, not carrying out cash. What else? Ashika or Ashika, I don't know. Am I pronouncing your name correct? Ashika or Ashika? Anyways, okay, Ashika, got it. Safety. How? How is it safe to use checks? It's okay to get it wrong. Everyone gets that. Don't worry. Why do you say? Because your answer is correct. Why do you say it's safe to use checks rather than cash? The answer is there itself in the question. So until you answer, the others, why? Why? Checks. And are there any tellers here? Tellers in the banks? Any tellers? No? No tellers? How do you prefer, you as a customer, let's say you as a consumer, how do you prefer, uh, yeah, good, Najma, okay. How do you prefer, uh, uh, as a consumer, how do you prefer to pay for the, let's say, for the groceries that you um, bought? This is a simple question. This is nothing to do with law, so to speak. As a consumer, you as a consumer, how do you prefer to pay the grocery for the groceries that you bought? Let's say your grocery bill is uh, this is your grocery bill, and then how do you prefer to pay? Why? By card or cash? Some says by card or cash. Why? Others, there are quite a lot of people here. People. So why? How do you prefer to pay? Yes. Why card or cash? Come on. This is simple question I'm asking. Oh, convenient to use card than cash. Convenient. How is how, So that's what I'm asking. How is it convenient to use the card rather than cash? How? How is it no need to carry bulk of money? Okay, that is one. What else? What else? No need to carry bulk of money. So that's convenience. What else? What else? What else? Ah, yes. Yes, 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 yes. Easy for the transaction. It's easy to pay the exact same amount. Can pay the whole amount at once if cash is not available in hand. Yes, yes, yes. Especially when it comes to sense, of course, yes. You know, sir, rupiah card dekada under the points or add under the sir maruna toffee cut the you have seen no the Sri Lankan rupee and 5 rupees in different sizes and shapes in Sri Lankan shops. And the fact that if there is a balance that you for example this amount, right, accurate, yes, easy to monitor, very good examples. Now these examples you need to keep this in mind, right? 6422 28 cents 72, and then just imagine your, I don't know whether this is right or wrong, but then again, imagine your stance. You give him 6,500 and he gives the remaining amount, right? 530 or 570 rather. And then you wait for your 1 rupee and 50 cents, and then he looks at you like that you are descendant from somewhere, Mars or something, right? Inconvenient. Right? So look at this. No need to carry bulk amount of money. These are your answers, not mine, right? It's easy to pay exact same amount. Very good. Easy for the transactions. These are absolutely valid answers. Can pay the whole amount at once if cash is not available in hand. How would you feel like that? Right? You go and buy something, and then again, you constantly, some people are checking whether they have enough cash to buy whatever the things that they bought. Sometimes you don't have a red cent in your wallet. Even sometimes you come across, personally I come across, you don't have a red cent in your wallet to pay the parking fees, right? You come across things like that, especially when it comes to cents. Yes, needs to be accurate, and if you can pay the exact amount, right? Everything what you have mentioned here is applicable for checks as well, isn't it? Right? You if they are accepting checks, same thing applies. Easy to monitor. How valid is that? Even from simple things as managing your what do you call finances. How easy that would be for you to manage your expenses, because your record is there. It's in the banking statement, it's in your transactions list. If you have mobile banking, whatever you call it, you have what not today, right? Everything is there. Yes, we have a record of. So advantages of use of checks as means of payment, you can use that. I'm not going to bore you out of any other examples that I might have. So the distinction between checks and bills of exchange is provided in. I see some past students of mine also. So I think I'm privileged to get your assistance also. I see the names now. Don't log out, right? Uh, right. So good to see you all. As a refresher for those who are repeating, in the sense not repeating, you are just participating. So you have do enlighten with your knowledge as well. So distinction of bills of exchange in general and checks is provided under section 73. Rather, it's defined as to what check is, right? It's a bill of exchange drawn on a banker payable on demand. Drawn on a banker payable on demand, right? On the other hand, while all checks are bills of exchange, uh, right? All checks are bills of exchange. All bills of exchange are not checks. That is the main difference. All checks are bills of exchange, but not all bills of exchange are checks. Section 73 defines a bill of exchange drawn on a bank is a check. Bank payable on demand. Keep that in mind, right? Then we are going to discuss 8 other characteristics of checks, how it differs, checks and rather bills of exchanges, how it differs from bills of exchange, right? Look at this. It's as follows. An authority to draw checks does not necessarily include an authority to draw bill of exchange. Include an authority to draw bills of exchange. First one. Why? An authority to draw checks does not necessarily include an authority to draw bills of exchange, because all checks are bills of exchanges, but not all bills of exchanges are checks. For example, you give your agent authority to draw checks on your behalf, because all checks are bills of exchanges. That doesn't mean your agent has the authority to draw other bills of exchange which are not checks, because of that reason. That's the first one. Apart from the law, the distinction between checks and the ordinary bills of exchange arise from the relationship of customer and banker, subsisting between the drawer and drawee of the check, right? So I will put it like this: distinction between checks and exchange arise from the relationship of customer and banker, right? Subsisting between drawer and drawee. That's the second one, right? That's quite evident, quite obvious. Keep that in mind. Third one is a check is intended for prompt presentment, while a bill of exchange payable on demand is deemed to be a continuing security. Promissory note. It's not a check. It's not a bill of exchange either. Nevertheless, since it's under bills of exchange ordinance, it's a promissory note. It's a continuing security. Check is not intended for that. A check is not intended to be used as security. It's a bill of exchange. It's a negotiable instrument. It's a bill of exchange. It's not intended. So that's why Section 7 of Money Lending Ordinance, bankers have this in your mind. Give me a moment. It's section Mm. Money lending. Server 13. Thinking it's section 13. I'm reading section 13 of money lending ordinance. Listen to this. Any person, including a banker, who shall take as security for any loan, a promissory note, or other obligation in which the amount stated as due is to the knowledge of the lender fictitious, or in which the amount due is left blank, shall be guilty of an offence and shall be liable on conviction to a fine not exceeding 500 rupees, or in the event of a second or subsequent offence, either to a fine not exceeding 1000 rupees or simple imprisonment for a period not exceeding 6 months. Meaning of fictitious: a promissory note given in respect of a loan with regard to which its reduction was made or sum paid at or about the time of the loan in respect of interest, premium, being set forth upon document in section 10, which entitles the lender to relief under that section, and any promissory note or other obligation in respect of the loan with regard to which at or above the time of the loan any payment was made or collateral entered into with view to distinguishing the actual amount of sum advance or the rate of interest payable thereof shall be deemed to be a promissory note. This explains what a promissory note is all about. Shall be deemed to be a promissory note or obligation in which the amount stated as due is the knowledge of the lender fictitious within the meaning of section 2 and 13 of the ordinance. You can go home and read this section 13 and 14, which explains what is fictitious, right? It's an offense. So we are here. The ordinary bills of arise from the relation customer and bank. Check is intended for prompt settlement. So that's why you use checks, right? Prompt presentment. The bill of exchange payable on demand is deemed to be a continuing security. Right? Continuing security. You can't have checks as security. That's illegal. But bankers, finance companies, for a fact I know, they do this. That's an offense. And mind you, with the latest developments in the banking sector, as developments I mean the litigations, you will be held personally liable for doing some action like that. Keep that in mind. Right? I can give you case references as well, where the directors and the senior managers have held the person liable as the one who is below their rank. Right? So if you are violating the law by doing certain things of that nature, be careful. That's what my advice is. Right? You can't keep checks as security. Undated checks, blank checks from customers, you will be dealt with. These are criminal actions, right? There are criminal, results, criminal results and sanctions rather, right? So be careful. A check, unlike a bill of exchange, is not in the ordinary course accepted. No. There are certain limitations and restrictions and observations that you need to see to when you are dealing with checks. You can't go to the bank and present a check at wee hours in the night. You can't go at 9 o'clock or 10 o'clock and say, you bang the door of the bank and say, look here, you accept my check. You can't do that. Right? There are criterias. So as being bills of exchange, they are capable of being accepted if the banker so chooses. Right? So that's the fourth one. Right. Checks are always drawn on a banker. Checks are always drawn on a banker. always a banker, right? And are payable on demand. Accordingly, no days of grace are allowable, and nothing protesting and acceptance for honor and dishonor and notice of dishonor, etc., which are required for normal bills of exchange, is associated with the checks. Then the sixth one, in practice, while bills of exchange are used in the conduct of most overseas matters, documentary credits and stuff like negotiable instruments, right? Checks are largely used for local transactions. Largely. Seventh one, while bills of exchange may be used by businessmen other than bankers, you cannot have a check without it being drawn on a banker. Checks are always drawn on a banker. Only bankers can handle checks, while even businesses that are not banks can handle bills of exchange, right? Keep that in mind. And the last explanation or the distinction between these two are is now, since Mackenzie Chalmers, you remember who Mackenzie Chalmers is? This is the guy who drafted the English Bills of Exchange Act in 1882, right? They put both the bills of exchange and checks both in the same law or same statute. The legal rules governing checks got complicated because of this historical identification with bills of exchange, right? But there are distinguishments that distincts checks from bills of exchange. In commercial practice, the two instruments played entirely different, right, roles because of the intended purposes and the largely drawn custom. Any questions? Any questions? If no questions, I'm going to go. Now, I now said the basic or the foundation for bills of exchange and checks, right? Now I'm going to go in a bit of a, what do you call, comparatively accelerated way on certain aspects and characteristics of checks. First one is the dual aspect of a check. This I've seen so many times question in the past papers. මොනද මේ check පතක ද්විත්ව කාර්යභාරය වුණ, what is the dual aspect of a check? Dual check, right? There is a dual role. On the one hand, it is subject to the bills of exchange ordinance and it could be considered as a negotiable instrument. First one, that is subject to the bills of exchange ordinance and can be considered as a negotiable instrument. Second, that on the other hand, right, from a banker's point of view, it's an order, or it's rather a mandate given to the banker, so issued to the bank's customer, requiring to pay a stated amount of money to a party on or after the date of the check. On or after the date of the check. So first thing is, it's a bill of exchange, which is covered under the bills of exchange ordinance, and it's a negotiable instrument. Secondly, it's a mandate given to the bank by the customer to pay a sum amount certain money on or after the date mentioned in the check. Right? So you keep these things in mind when you've been questioned, or if you are questioned as to what is a dual aspect of a check. Don't forget this. This is quite important. You keep in mind there are no separate legislation or no statutes for checks and bills of exchange. Both are in the one and the same bills of exchange ordinance of in Sri Lanka, which governs this, right? So the definition we have covered. Then checks. Then we go to crossings of check. There are certain rules which governs crossings of check. Check patre करने के लिए, right? This, keep in mind, this originated out of the practice of the bankers or crossing. Originally, it was placed on checks only by bankers in the process of clearing for their own benefit, right? How it went, what the book says is, the law books and the history book says is, the original clearing houses, each bank had a box. Original clearing houses, each bank had a box with their name on that, right? Marked on that. So the clerks from the collecting banks, the paying bank is there, the collecting bank is there. We will discuss more towards the coming times. Would leave checks drawn on the banker in the box or marked, right? So the clerks of the collecting banks who holds the check on behalf of their customer, checks drawn on other banks, what they did was they leave the check in that particular paying bank's box, right? So mark. But in order to indicate the bank to which payment was to be made, what did they do? But you put it there. But for an example, let's say I'm Sampath Bank, right? I'm talking about the medieval ages. Let's say Sampath Bank, I'm the collecting bank. The check is commercial bank check. I take this check and put it to the commercial bank box. But the commercial bank, the paying bank doesn't know to whom the payment should be made. So the clerk, I would cross the check, that is, write the name of the collecting bank. What I would do is in this check, I would put this parallel line and say Sampath Bank and put it into that, right? Then they know to which bank the funds should go to. In true transverse lines on the check. As the practice became known to the general commercial community, it was recognized as a significant safeguard against fraud. So otherwise, the people or the bankers wouldn't know it was the origin to whom the check should be payable to. So once I get that amount, the corresponding amount, I will credit my customer. That's how it originated. Now, it was given statutory recognition in England by a series of acts, commencing with the Cross-Checks Act, so on and so forth. In Sri Lankan Bill of Exchange Ordinance, section 76 and 77 covers crossings, right? Right. Crossings on check are part of drawer's mandate to his or her banker. They must consequently be clearly indicated, right? It's been aptly said, just as people are urged by the railway department to cross railway crossings cautiously, so should banks request their customers to cross checks carefully. That's a nice idiom, right? So just by the railway department instructs the people to cross railway crossings carefully, so should the banks request their customers to cross the checks carefully, right? Now, effect of crossing of the checks we will see. This again was questions quite frequently in the past papers. Now, it's a direction to the bank. I said, that to be paid only to another bank, right? Paying bank, that the check, direction to the paying bank, that the check should be paid only to another bank. Bank can ignore the crossing and pay a cross check over the counter. If there is a check and two parallel transverse lines and I give it to and the name of the bank and give it over the account to the bank, paying bank. The paying bank can ignore that and pay it over the counter. However, if it later turns out that the person paid was not entitled to receive the amount, the paying bank will be liable. Right. To the true owner and will also forfeit the statutory protection of the ordinance. Because it's a mandate, it's an instruction, it's a direction given to the bank. You pay, it's crossed, right? And name of the bank. What does it do? It ignores that direction, instruction, and pay it over the counter. If you ignore that direction by the bank, not direction by the bank, if the bank ignores that direction, the bank will have to take the responsibilities coming after that, right? Arising out of that, right? This is because payment of a check in contravention of crossing would be regarded as negligence by the bank, right? Then section 76(1) of the Bills of Exchange Ordinance provides types of crossings. There are two types of crossings. One is a general crossing and the other one is special crossing. So general crossing is where a check bears across its face an addition of the words "and company" or any abbreviation thereof between two parallel transverse lines, either with or without the words "not negotiable," or two parallel lines simply either with or without the words "not negotiable." That addition constitutes a crossing. That check is generally crossed. So you can have the check two parallel transverse lines with or without the word "not negotiable," right? That's general crossing. Special crossing is same two parallel transverse lines in addition of the name of a bank with or without the words "not negotiable." That addition constitutes a crossing and the check is crossed specially and to that banker, right? Understand? Okay. Now understand what do you mean by not negotiable crossing. Where a person takes a cross check which bears on it the words "not negotiable," he shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it had. That is not negotiable crossing. Section 81, where a person takes a cross check which bears on it the words or not negotiable. He shall not have and shall not be capable of giving better title to check than what the person from whom he took it had. Right? Now, earlier, I told you to keep in mind about holder in due course, section 29. If the holder was not been warned of any possible defect in title, he is a holder in due course. Go to section 29 later on and check it. Right. Now, not negotiable is a warning. Is a warning to the holder to say that the title of this check may be defective. It's a warning. Not negotiable. Not negotiable doesn't mean it's not transferable. Right? It means it's not negotiable. That means whoever whom you took the check from cannot give you a better title than that he had. That's a warning. So you become a holder only. You don't become a holder in due course. ඔබ ධාරකයෙක් වෙනවා පමණි ඔබ යථාකාලී ධාරකයෙක් නොවේ. Meaning if by any chance the person who endorsed the check to you on a not negotiable with a not negotiable crossing had a failed or bad title, he cannot pass you a better title than that he had. Right? Meaning you can't sue the chain of title before that. If it's not, because you've been warned. If not negotiable is there, you become a HDCO holder in due course or yata khali dharakya. Right? Understand? Good. Then you have account payee crossing. Now, it operates as a notice to the bank that only the account of the pay is to be credited and not anyone else. Account of the pay. It may be the payee or once it's endorsed, the endorsee. Understand? Right? But keep in mind the account payee checks the fact of account payee. It's not covered anywhere in the bills of exchange order. It's completely arising out of the practice of the bankers. Right? Right. Who may cross the check under section 77? The check is uncrossed, the holder may cross it generally or specifically. If it's crossed generally, the holder may cross it specifically. If it's crossed generally or specially, the holder may add the words not negotiable. The check is crossed specially, the bank to whom it is crossed may again cross it specially to another bank for collection. So you cross it bank, another bank, the bank to whom it is crossed can cross it again to another collecting bank. You can do that. Crossing is a material part of the check. Right? There are protections to the paying bank as well as to the collecting bank. For the protection to the paying bank is covered under section 80 and collecting bank protections are covered in section 82, where a bank on whom a cross check is drawn in good faith and without negligence pays it if crossed generally to a banker, if crossed generally to transverse lines, general crossing, and if crossed specially to the banker to whom it is crossed. So earlier it's crossed generally to a banker, it's crossed specially to the banker. Right? So for an example, you have two transverse lines. You get a check, right? You are the payee, crossed generally, right? It's just crossed generally. You have to route it through an account. There's no two words about it because it's drawn on a banker. Let's say it's a commercial bank check and you have your accounts in Sampath Bank. Right? You have your accounts in Sampath Bank. You can deposit it to Sampath Bank. Right? But if the check that you receive, same example, was crossed specially, let's say it's crossed to HMB, crossed HNB, you can't deposit to Sampath Bank. You have to deposit to HNB. You have to open an account in HNB, you have to deposit it, right? Because it's cross specially. What happens is if a paying bank, if it is a cross specially to the bank to whom it is crossed or his agents for collection, being a banker, the banker paying the check, and if the check has come to his hands to pay, the drawer shall respectively be entitled to the same rights and be placed in the same position as the payment of the check to be made to the true owner thereof. The bank has to be very careful when they are the paying bank, when they are paying a check. If it's cross pay, it pays it if it's crossed specially to the bank which it was crossed to, right? Now if it goes beyond this, the bank is held liable for negligence, right? Then you come across checks, the protection given to the collecting bank, right? In relation to cross checks, given under section 82. Now, all sections related to checks in this section has resulted in most number of, because there are so many judicial decisions with regard to this, because fraudulent people try to make use of collecting banks, because there's a gap on the paying bank and the collecting banks to obtain funds of checks that do not belong to them. What happens is the collecting bank doesn't know the signature of the drawer, so there are more steps involved when it comes to the collecting bank. And unless the collecting bank can claim protection under Section 82, it will generally be liable. So Section 82 goes as this: where a bank in good faith and without negligence receives payment for a custom of a check crossed generally or specially to himself, and the custom has no title or has a defective title thereto, the banker shall not incur any liability to the true owner of the check by reason only of having received such payment. There is a legal principle called passing off. That means passing off is what do you call? Using or tampering with the property of without the authority of the true owner. Tampering with the property without the authority of the true owner. Now, here the same thing applies. When the collecting bank takes that funds and put it to an account which he thinks is the owner, and it is not the case, and the true owner of that funds is not his customer, he is guilty of passing off. So the protection given under Section 82 is a indemnification to the collecting bank from passing off. It says, if they in good faith and without negligence receives payment for a customer of a check crossed generally or specially to himself, good faith and without negligence. Now, without negligence, how many things a bank should be aware of? Certain things are so much so that it's a bit quite a difficult line to draw whether they have done the checks that they are required to be done, right? So if you have done that, customer has no title or has a defective title. For example, the customer received a defective title, a not negotiable check, where value has not passed. The collecting bank cannot be held responsible for that, right? And shall not incur any liability to the true owner, right? Right, so we checked on not negotiable and account pay crossings. Right. Now, I'm asking you a question. Answer. What is a stale check? Anyone heard? What is a stale check? Answer this question, please. What is a stale check? What is a stale check? Yes. Simple answers. I don't need any lengthy answers. Like stale food? Is it? What is a stale check? Yes. Stale check is an expired check. Yes. What is the duration of the validity of a check? What's the duration of the validity of a check? 6 months. Uvinya, why do you say it's 6 months? Who said it's 6 months? Others also? Janani, Yeah, why 6 months? 6 months. Everyone is saying 6 months. Who said 6 months? I'm asking from the bankers. Why 6 months? Hmm? Why? It's not written anywhere. In Sri Lanka, it's 6 months. Yes, you all are correct. Your answer is yes. This is purely due to banking practice. It's not stated anywhere, right? It means the check. No, stale check in Sri Lanka means which is a check which is more than 6 months old after the date on which it was drawn, right? As uniform rules in Sri Lanka, banks in Sri Lanka follows the practice from England and do not pay a stale check. The reason that they write as the written reason is stale check, right? The dictionary meaning is no longer fresh, stale. Yes, of course, like stale food, no longer fresh, right? Impaired or affected by lack of time. In some countries, it is governed under the statutory rules. In Sri Lanka, it is not the case. For an example, a check is stale not in 6 months, right? But not in 6 months, but in 15 months. Formerly in Australia, it was 12 months, but it was found that every new year, customers forgot the change in the year and wrote the old year in dating the check. So without writing that, they said they changed it from 12 to 18 months to overcome this problem. Right? Keep that in mind. Now, if a bank pays a stale check, the bank is liable. The paying bank as well as the collecting bank for negligence and directly liable. If the and they return the check. Now, why is this whole concept there? That is to ensure once the drawer pays and gives out a check, there should be a period, a limited period where the payee can or the endorsees can encash the check. Otherwise, the drawer will lose track of the check as well. If it is given for an indefinite period, and you have to manage your cash flows, you have to do your accountings and stuff like that, reconciliations, everything. So in order to address those issues is why the stale checks are there, right? uh, There are a little bit further, a little more to cover under the Bills of Exchange Ordinance. So we are going to wrap up for today and continue next week. And I'm going to finish Bills of Exchange Ordinance next week. Like I said earlier, this is the email I've dedicated for IBSL for your queries and everything. You can write your queries to this. Then we are going to discuss the new chapter on, once we are done with bills of exchange, we are going to discuss about debt recovery laws, right? That is Debt Recovery Act and Recoveries of Loans by Banks, Special Provisions Act. Those are comparatively. This is now Bills of Exchange Ordinance is one of the longest or lengthiest areas which you have in your curriculum, as well as for the bankers. Quite important area. Personally, I'm also very keen on this area. Not everyone is aware of the legal provisions and the practices involved in because Mackenzie Chalmers is the guy who you need to speak to. It's a joke. Anyway, then we will go on after concluding the next week on bills of exchange. What I'm planning to do is the debt recoveries. All right, so we'll call it a day. All the best.